Namaskar. Today we will discuss about few issues relating to assessment of a deceased person which comes to the mind of natural persons. Like, can a proceeding be continued which was initiated against the deceased SSC before his death? The answer is, as per section 159(2)(a), any proceedings initiated against the SSC before his death shall be deemed to be have taken against the legal representative and may be continued against such legal representative for the stage at which it stood on the date of the death of the deceased person. The important point is the proceeding can be continued if the AO put on record the legal representative or heir of the deceased SSC. The liability of the deceased SSC under section 159(6) shall be subject to the provision of subsection 4 and subsection 5 be limited to the extent to which state is capable of meeting the liability. There are a number of court judgments on this topic. Recently, the Jharkhand High Court, in the case of Sandeep Chopra versus Principal Commissioner Income Tax, held that notice issued under Section 148 for initiation of reassessment proceedings in the name of the deceased SSC on his pen and not in the name of his legal representative is illegal and bad in law. The next question which comes to the mind of a natural person, a normal person, can a notice be issued to a deceased SSC? The answer is no. Notice cannot be issued in the name of deceased SSC. As per section 159, where a person dies, his legal representative shall be liable to pay any sum which the deceased would have been liable to pay if he had not died. Here again a important question. If the legal heir is not brought on record and no notice in the name of legal heir issued, then the assessment order framed in the name of deceased SSC will be bad in law and liable to be quashed. There are number of judgments on these subjects. Recently, the Mumbai Tribunal, in the case of Motilal Hasti Masjid Bothra versus ITO, held that where a SSC deceased expired much prior to passing of assessment order and issuance of notice, and his legal representative was not brought on record and no notice was issued in the name of legal heir, assessment order framed in the name of deceased SSC was bad in law, hence was to be quashed. The next question which comes to the mind is, can a reopening notice under section 148 be issued against a dead person? The answer is no. Reopening notice issued 148 of the Income Tax Act against a dead person will be nullity, and proceeding pursuant to that notice issued to a dead person cannot be continued against a legal representative. Any notice issued to dead person is bad in law. The AO can issue notice to the legal representative if the legal representative submit himself before the AO and the time limit prescribed under section 149(1)(b) has not expired. This point also we have to see. Similarly, the Gujarat High Court, in the case of Shrimati Madhubehan Kantilal Patel versus Union of India, held that where a petitioner, legal heir of the SSC deceased, had supplied that certificate of the SSC to the concerned AO within a short period of after her demise, reopening notice issued subsequently under section 148 in the name of the deceased was illegal and thus liable to be set aside. Similarly, Gujarat High Court in the case of Chandresh Bhai Jayanti Bhai Patel versus ITO, in this case, the Honorable High Court held that where a original SSC died and thereafter assessing officer issued a notice under section 148 in his name to reopen the assessment, and petitioner being heir and legal representative of the deceased raised an objection. The SSC has already expired and therefore notice in his name was not valid merely because petitioner had informed the AO about the death of the SSC and asked him to drop the proceeding. It could not be construed that petitioner had participated in the proceedings and therefore the provision of section 292B would not be attracted, and notice under section 148 was to be treated as invalid. Recently, the Karnataka High Court in the case of Mrs. Vanitha Gopal Shetty versus ACIT held that since the notice was issued under section 148 before 31st March 2018, the very commencement of the reassessment proceeding as per the notice was invalid. In this case, the notice was issued 148 in the name of assessee who was a UK citizen for the assessment year 11-12. Thereafter, the department was informed about the death of the assessee by email. The authorities issued a notice under section 142 dated 19 November 2018 and notice dated 21st December 2018 to the legal representatives. Reassessment order has been passed in the name of legal representatives under section 144. Legal representatives of assessee contended that the period available for the initiation of 148 as per section 149 would be 6 years from the end of the assessment year, that is from 31st March 2012, which could be extended up to 31st March 2018. And the notice issued under section 148 on 28th of March 2018 within the prescribed limit was issued against the deceased assessee, and notice to the petitioner, that is legal representative, on 19th of November was issued 142. Since no notice under section 148 before 31st March 2018 issued, hence the notice was invalid. Next question which comes to the mind is whether notice issued to the dead person is simply a procedural defect which can be cured. The answer is no. After going through the provision of section 292BB of the Income Tax Act, it is to be noted that the intent of the section does not save the complete absence of notice. It is only the infirmities in the manner of service of notice that section seeks to cure. There are a number of judgments on this subject. Recently, the Honorable Delhi High Court in the case of Rajendra Kumar Sehgal versus ITO held that the Honorable High Court held that where a notice seeking to reopen assessment was issued in the name of deceased assessee, since she could not participate in the reassessment proceedings, provision of section 292BB were not applicable to the assessee case. As a consequence, impugned reassessment proceedings under section 148 deserve to be quashed. The next question which comes to the mind is, when it is said that here's a legal representative participating in the assessment or reassessment proceedings, the answer is if a person merely informed about the death of the assessee and not surrendered to the jurisdiction of AO by submitting return of income in response to the notice, an assessing officer has not issued notice to him as a legal representative representing the estate of the deceased assessee, impugned notice issued by the AO is invalid and should be quashed. If a person merely informed the AO about the death of the assessee and ask him to drop the proceeding, it cannot be construed that the petitioner has participated in the proceedings and therefore the provision of section 292B will not be attracted, and notice issued under section 148 is to be treated as invalid. Recently, Gujarat High Court, in the case of Vikrant Anthony Joseph versus ITO, held that there was no circumstances could be pointed out by the department, nor it emerged from the facts on record that the petitioner in any way submits about the jurisdiction of the income tax authority. In this case, mother of the petitioner died on 27th of May 2014, and he intimated the authorities about the death and submitted the death certificate. He also conveyed that he is not the only legal heir and not having knowledge about the transaction and income of the mother. Despite that, income tax authority proceeded to issue notice and pass the assessment order. In view of the above, the present petition deserved to be allowed by the Honorable High Court. It is allowed by holding that impugned notice which was against the dead assessee could not be sustained. Similarly, Gujarat High Court, in the case of Urmila Ben Anirudh Sinhji Jadeja case, held that reopening notice issued under section 148 against a dead person will be nullity, and proceeding pursuant to the reopening notice issued to a dead person could not be continued against the legal representative. Similarly, the Delhi High Court, in the case of Vipin Walia versus ITO, in this case, the Honorable High Court observed that what was sought to be done by the AO was to initiate the proceeding under section 147 of the Act against the deceased SSC for the assessment year 2008-9. The limitation for issue of the notice under section 147 and 48 was 31st March 2015. On 27th March 2015, when the notice was issued, the SSC was already dead. Even by issuing notice to the LR of the SSC, the 140A, if the department intends to proceed under section 147 of the Act, the department could have done so by issuing a notice prior to 31st March 2015 to the legal representative. Beyond that date, no notice can be issued to the legal representative. Hence, the Honorable High Court held that where the deceased department intend to proceed under section 147 against the SSC, when he was already dead, it could not be done so by issuing a legal notice to the legal representative of the SSC within the time limit for issuing the notice, not thereafter. Similarly, the Honorable Gujarat High Court, in the case of Kannu Bhai Dhiru Bhai Patel versus ITO, held that in this case, assessing officer issued notice under section 148 on 31st March 2021 to the SSC calling him to file the return of income for the assessment year 15-16. The writ applicant, who is a legal representative of the SSC, responding to the said notice by submitted that the SSC died on 22nd November 2020 and further requested to drop the proceeding. As such, notice would have no legal sanctity in the eye of law. Even thereafter, notice under section 142(1) initiating further proceedings issued on 17th of December 2021, once again in the name of deceased SSC. On a writ applicant contended that impugned notice were bad in law and have been issued to a dead person. The Honorable High Court held that where a assessing officer issued notice under section 148 to the SSC to file the return on 30th March 2021 and the writ applicant, legal representative of the SSC, informed the death of the SSC on 22nd of November 2020 and the writ applicant had not surrendered to the AO by filing a return of income in respect to the notice. AO had not issued notice to the legal representative representing the estate of the deceased SSC. Notice issued by the AO is invalid and should be quashed. Thanks for watching.